Hello everyone, it's Aprilia and welcome back to my channel. So today I'm going to tell you about how maritime law applies to oil field work. Okay, not many individuals realize that customary federal or state laws don't govern oil field work. Maritime law, called admiralty law, is an international system that regulates offshore conduct. It applies to all seagoing ships, whether cruise ships, fishing boats, or oil rigs. If you suffered injuries on the job, you might be wondering whether maritime law applies to oil and gas workers. The answer to this question is yes. You do have right under maritime law as an oil or gas worker. You may seek and recover compensation for your medical care, lost wages, and perhaps other losses after an on-the-job injury. Nevertheless, which maritime laws apply can greatly affect your case. This might include what you need to establish in your case and the damages or benefits you can recover. Thus, you may want to work with a maritime law lawyer to help you understand your privilege and legal choices and how the Jones Act can benefit you. And then the next, how does the Jones Act apply to oil worker? How does the Jones Act apply to oil and gas employees? Per number 46 U.S. Code Section 30104, commonly called the Jones Act, offshore workers may recover damages based on their injury or illness. Nevertheless, they must first satisfy the requirements set by this regulation for being a seaman. A part of this test to resolve if workers qualify is that they must dedicate a significant portion of their working hours, usually more than 30% to offshore work. Most oil and gas employees exceed this minimum effortlessly. Jones Act to recover them and help them get compensation. You can get assistance understanding what the Jones Act does from a personal injury law firm that handle this suit. They can also resolve these maritime laws apply to your case and your best opportunities for getting paid. When does the Jones Act not cover oil and gas employees? Okay, there's one primary reason why some oil and gas employees don't qualify as seamen and don't obtain the legal safeguard given by the Jones Act. This applies to employees who labor onshore or on oil platforms. The Jones Act only covers navigable ships, not moored or permanently docked vessels. A fixed oil platform is always on the ocean floor. If this applies to where you labor most of the time, you may not meet the standard of the Jones Act. Just because you don't qualify as a Jones Act seaman doesn't mean you don't have legal privilege. You may still have protection and seek compensation under the Longshore and Harbor Workers Compensation Act, or LHWCA. The LHWCA will probably apply if your oil or gas rig doesn't meet the Jones Act definition of a qualifying vessel. Okay, what is the distinction between the Jones Act and the LHWCA? The Jones Act, the LHWCA, and maritime law allow seeking compensation following a negligence injury or an unseaworthiness claim. If you were working and suffered damages, you should have a path to seek and recover benefits. The Jones Act and LHWCA provide further causes of action and types of damages recoverable cover general maritime law. The Jones Act provides a more comprehensive range of recoverable damages. Nevertheless, there are weaknesses. These actions are insurance claims or civil suits against your employer, the vessel owner, or another liable party. You can arrange a settlement or take the case to a jury trial. This process can be long, but you can recover the first medical care expenses and then lost wages, pain and suffering damages, and then the LHWCA typically delivers a quicker turnaround and functions much more similar to a standard workers' compensation case. The damages recoverable are usually restricted to wage losses and medical treatment recover unless there are permanent injuries or death, when additional benefits may be available. What laws apply to the safety of What laws apply to the safety of offshore oil and gas rig workers? Like other maritime employees, oil and gas rig workers have the right to fair working conditions with proper safety measures. Despite the risky nature of the job, offshore oil and gas rig employees are protected by several laws, including the Jones Act, the Longshore and Harbor Workers and Compensation Act, and the Outer Continental Shelf Land Act. The relevance of any of these laws depend on where the accident happened, the job duties of the injured worker, and the accident circumstances. And then the Jones Act and Workers' Compensation. The Jones Act started in 1920 as the Merchant Marine Act. At the time, sailors hard at sea had no legal way to seek payment. Traditional workers' compensation did not apply and maritime law had no match. When presented, the Merchant Marine Act allowed injured sailors to support an action for their damages. It's been revised several times since enactment known today as the Jones Act. Initially, the Jones Act only applied to boats and barges. However, as of a 2005 court ruling, oil rigs become qualified as vessels under the Jones Act. This means the Jones Act covers oil rig workers. The term employment is essential. The definition may differ depending on whether the employee is a blue water seaman or a brown water seaman. A brown water seaman's privilege under the Jones Act may end when they step off the boat. However, this right may extend for a blue water seaman even if their injury happens while onshore or while going to and from work. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe the channel. See you in the next video, and bye-bye.